Shawn P. Diddy Combs has been arrested in New York City by federal agents after being indicted by the Southern District of New York on racketeering charges. Since the indictment became a part of the public record early today, there have also been additional court documents released regarding the government's request to have Mr. Combs held without bond pending this legal fight, and also his lawyer's response about the parameters in which they want a bond to be granted. So let's first take a look at the video of the lead prosecutor, U.S. Attorney Damian Williams, talking about these charges, and look at both the government's request for the judge to deny bond and Diddy's attorney's response to that filing. So hi, my name is Rochelle and I'm an attorney. Even though I'm an attorney, I'm not your attorney. And this video is for entertainment purposes only. It is not legal advice. So we're going to begin this video looking at the U.S. Attorney Damian Williams talking about this indictment and kind of summarizing the charges that have been asserted in the complaint against Diddy. Then we're going to turn to a letter that was filed on behalf of the government and submitted to the judge handling this case, outlining why the government believes that Diddy should not get a bond and that Diddy should be held in custody during the pendency of this lawsuit. And then we'll take a look at the government's response.
Carry out this conduct, Shawn Combs led and participated in a racketeering conspiracy that used the business empire he controlled to carry out criminal activity, including sex trafficking, forced labor, kidnapping, arson, bribery, and the obstruction of justice. Let me say a little bit more about the charges. The indictment alleges that Combs abused and exploited women and other people for years, and in a variety of ways. As alleged, Combs used force, threats of force, and coercion to cause victims to engage in extended sexual performances with male commercial sex workers, some of whom he transported or caused to be transported over state lines. Combs allegedly planned and controlled the sex performances, which he called freak-offs, and he often electronically recorded them. The freak-offs sometimes lasted days at a time, involved multiple commercial sex workers, and often involved a variety of narcotics, such as ketamine, ecstasy, and GHB, which Combs distributed to the victims to keep them obedient and compliant. As alleged, when Combs didn't get his way, he was violent, and he subjected victims to physical, emotional, and verbal abuse so that they would participate in the freak-offs, and that Combs hit, kicked, threw objects at, and dragged victims, at times by their hair. On one occasion in March of 2016, that conduct was captured on video and later reported in the media. Specifically, Combs kicked, dragged, and threw a vase at a victim in a Los Angeles hotel when the victim was attempting to flee. As alleged, these assaults often resulted in injuries to the victims, which took days or weeks to heal. In addition to the violence, the indictment alleges that Combs threatened and coerced victims to get them to participate in the freak-offs. He used the embarrassing and sensitive recordings he made of the freak-offs as collateral against the victims. And the indictment alleges that he maintained control over the victims in several ways, including by giving them drugs, by giving and threatening to take away financial support or housing, by promising them career opportunities, by monitoring their whereabouts, and even by dictating their physical appearance. Because of all of this, the indictment alleges that the victims did not believe they could refuse Combs without risking their security or facing more abuse. The indictment also alleges other acts of violence undertaken by Combs and others, including violence against witnesses to his abuse, kidnapping, and arson. The indictment alleges that on more than one occasion, Combs carried or brandished firearms to intimidate and threaten victims and witnesses. Now, Combs did not do this all on his own. As I mentioned, Combs has been charged with RICO conspiracy, He used his business and employees of that business and other close associates to get his way. Those individuals alleged.
So we listened to Damian Williams, and here is a copy of the indictment that was recently unsealed today. I will pin this document in the description so that you can take a look, but I think Mr. Williams, the U.S. Attorney, does a great job of kind of highlighting some of the key things that are outlined in this indictment. If you've been following the Diddy story, then you will note that a lot of the things that are mentioned in this indictment really are a repeat of allegations that we've heard both in Cassie's lawsuit and in other lawsuits that were filed by other individuals, both named and unnamed, against Diddy. But what is some kind of new information that we want to take a look at first is this letter. So today, September 17th, the U.S. Attorney's Office sent a letter to the judge. This is the Judge Tarnofsky, outlining exactly why the government believes that Diddy should not receive bond, should not be granted bail, should not be free while this lawsuit is pending. Now we know from some sound bites from Diddy's attorneys that Diddy denies all of the claims alleged against him in this lawsuit, and he indicated that Diddy plans to fight, these charges. So we know this is going to be a hard fought legal battle. And so the government says, hey, listen, the court should detain him. So here's the second sentence. The government respectfully submits this letter in anticipation of the defendant's appearance before the court today in support of the government's request for the defendant's detention pending trial. The government's position is there is no condition or combination of conditions that will reasonably assure the appearance of the defendant as required and the safety of others and the community, not to mention the integrity of the proceedings. So this is the government's kind of position. What I want to kind of move down to, because I did take a peek at this before the video, is kind of looking at some of the more details about what allegations that the government has found that are really supporting their request for the charges outlined in the indictment. Now we know from the indictment that the time period that they're looking at is sometime in 2008 up until the present. They believe that the conduct at issue in the indictment, that's when this conduct occurred. But we don't have a lot of details about what specific acts they allege that Diddy participated in that are leading to them filing this indictment against him. So let's take a look, because there are some more details in this letter. So Section A, Combs' use of violence, threats, and coercion. So the government asserts the defendant and other members and associates of his enterprise, which is the Combs business, wielded the power and prestige of defendant's reputation as a musician, entrepreneur, and figure in the entertainment industry to commit federal crimes including racketeering, sex trafficking, and other offenses. As charged in the indictment, many of these crimes involve the sexual abuse and exploitation of women and other crimes of violence. Now, sex trafficking and abuse. I think that we have heard many allegations, both in Cassie's lawsuit, in the lawsuit filed by Dawn Richard last week, and other lawsuits, filed against Diddy about these alleged freak-offs, where, this is the government describes it, elaborate performances that the defendant arranged, directed, and pleasured himself, often electronically recorded. These freak-offs occurred regularly from at least in or around 2009 through this year, sometimes lasting multiple days and frequently involving multiple workers. The defendant arranged these freak-offs with the assistance of members and associates of his business enterprise, including employees and the hotel rooms where these freak-offs occurred. The hotel rooms are allegedly sustained significant damage as a result of the freak-offs. And we have a footnote. For example, in approximately 2012 in Manhattan, the defendant paid over $46,000 to cover damages to a penthouse hotel room following a freak-off. So what we kind of know, based upon what this is outlining, is two things. Number one, the government is still investigating all of these allegations in this complaint, and it's potential for other people who are considered co-conspirators, or those who assisted the enterprise, are potentially other individuals who may face indictment later down the line for what role they may have played in the events that are at issue in the indictment. The other thing we can assume, based upon this footnote, is that the government must have specific evidence regarding this incident in 2012 in Manhattan. So maybe they found this evidence through witness testimony, through documentation that they've either subpoenaed from Mr. Combs and his respective business entities, or information found when they conducted the searches of his multiple homes. So just this footnote suggests to me that, hey, they have some specific evidence about damage to this penthouse in this time frame. So going back to the letter, the defendant ensured that victims of the freak-offs would participate through coercion and violence, including providing controlled substances to the victims so that they would engage in the freak-offs despite fatigue, physical and emotional exhaustion, and pain. Additionally, both during freak-offs and separate from freak-offs, the defendant subjected female victims to physical, emotional, and verbal abuse, in part to cause them to engage in freak-offs. The defendant hit, kicked, threw objects at, and dragged female victims, sometimes by their hair. At least a dozen witnesses will confirm that they personally observed the defendant's violence towards women and or the injuries sustained by women at the defendant's hand. So there we have it. There are at least a dozen witnesses to confirm these allegations that are being levied against Diddy. Additionally, they're noting the March 2016 video that was publicly leaked back in May of 2024, capturing abuse by Diddy towards Cassie. They note the defendant's assault resulted in serious injuries to the victims that took days or weeks to heal. Okay. Also, allegations of coercion, which, we've heard of this before, specifically in Dawn Richard's complaint that we took a look at last week, where she talked about, Diddy holding over her head, him making threats, saying that he would end her, that people disappear, that, she would suffer professional harm if she were to, expose some of the things that she observed and that she personally experienced. So we kind of have gotten a preview of what this conduct that the government is alleging, what the testimony might be based upon other individuals who have filed lawsuits who have alleged this type of conduct against Diddy. Now, other violence. This one is interesting. So there is an example here in Section 2, other violence. For example, in the early morning hours of December 22nd, 2011, the defendant and a co-conspirator kidnapped an individual at gunpoint to facilitate breaking into and entering the residence of another individual. One. Multiple witnesses would testify at trial to the events surrounding the kidnapping and breaking in, the latter of which is corroborated by police reports and other records. Approximately 2 weeks later, the defendant's co-conspirators set fire to individuals one's vehicle by slicing open the car's convertible top and dropping a Molotov cocktail inside the interior. Police and fire department reports extensively document the arson and conclude that the fire was intentionally set. Multiple witnesses would also testify to the defendant bragging about his role in destroying individual one's car. Now, when I read that, I said, where have I heard that before? So we're going to take a look at Cassie's lawsuit. Okay, so in Cassie's lawsuit, she says, we're looking at, this is page 20 of Cassie's lawsuit filed back in November 2023, paragraph 106. In 2011, during a rough patch in Mr. Combs and Miss Ventura's relationship, Miss Ventura had a brief relationship with musician Kid Cudi. All right, fast forward. Miss Ventura ran away to stay at Kid Cudi's home to escape Mr. Combs' wrath. Soon thereafter, one of Mr. Combs' staff members told Miss Ventura that he needed to just talk to Miss Combs, even though Mr. Combs was enraged. Even though she felt like she couldn't escape, Miss Ventura returned to Mr. Combs. He hit her several times and kicked her in the back as she tried to run out the door. So then let's fast forward. In February 2012, during Fashion Week, Mr. Combs told Miss Ventura that he was going to blow up Kid Cudi's car, and he wanted to ensure that Kid Cudi was home with his friends when it happened. Around that time, Kid Cudi's car exploded in his driveway. So the complaint. Miss Ventura is putting this timeline around February 2012. We're looking at this. We're saying this kidnapping happened sometime in December 2011, and they're saying the explosion happened 2 weeks later. So the timeline of this could match up, and this could be the incident being described. It could be what Miss Ventura described in her lawsuit as the blowing up of Kid Cudi's car in his driveway. So that was interesting. I believe this is to substantiate the allegation in the indictment that that Diddy's enterprise engaged in arson. So moving back to the letter. More recently, there has been an outpouring of other public allegations against the defendant, including claims of threats and physical and sexual violence dating as far back as the 1990s. In short, the defendant's violent tendencies are widely known. However, at no point during the past few decades has the threat of public exposure or law enforcement intervention deterred the defendant from continuing his abuse. So the third section is about firearms, and in Mr. Williams' video, we kind of got a preview of the evidence where they detail 3 assault rifles, AR-15s, that were found in Diddy's residences, some of which had the serial numbers that were defaced, meaning they were hard for them to read. And we can kind of see in this photo, looking right underneath this skull, where it's difficult to read what that serial number is. So it states 2 of the 3 defaced AR-15s were found in the defendant's Miami bedroom closet, stored broken down in parts, along with magazines that were loaded with ammunition as depicted below. One of the AR-15s had a 10-round magazine loaded with 10 rounds of large caliber ammunition, while the second had a 30-round magazine loaded with 19 rounds of ammunition. They also seized a large capacity drum magazine loaded with 59 rounds of ammunition. So in addition to these guns, he also had 6 legally purchased guns with serial numbers, some of which were stored in gun safes. Although these particular guns, both the illegal and illegal firearms, were seized, their presence in the defendant's home demonstrates that the defendant has access to and surrounds himself with both guns and ammunition. Likewise, even if the defendant were personally restrained by the court, from obtaining new firearms himself, he could retain access to them through others. See footnote 4. Certain of the firearms seized during the March 2024 searches were licensed to a current member of Combs' security staff. In addition to that individual, during the course of the charged conspiracy, Combs has employed other security staff members with significant criminal history, including violent crimes and firearm offenses. So all this ties to the state's case that the defendant's regular use of violence and threats of violence against victims and others fostered a culture of fear in which the individuals believed that they were unable to reject the defendant's demands without subjecting themselves to physical violence or other abuse. And we see, because Diddy had in his possession, when these searches were conducted, these illegal firearms and 6 additional legal firearms, that if an individual were being threatened by Diddy, then they might also believe that he had the means to carry out those threats because of the heavy presence of firearms and ammunition in his homes. So that's the state's argument. Combs bribed witnesses and obstructed justice. So we have an example right here. This is going back to the 2016 incident with Cassie. There's a statement here. When a member of the hotel security staff intervened, the defendant attempted to offer the security guard a stack of cash to ensure his silence. There is the bribery. After the security guard refused the defendant's bribe, and after coordination between the defendant and his employees, the defendant's staff contacted other members of hotel security. At the same time, staff members were in close communication with the victim of the assault as well, all in an effort to cover up the defendant's assault and to prevent the incident from being publicly disclosed. Within days of the incident, the surveillance footage disappeared from the hotel's server. So obviously this is an example also mentioned in Cassie's lawsuit, which supports the government's position that Mr. Combs has bribed witnesses and hidden evidence, therefore obstructing justice in the past. And this is why they're trying to support their argument that, Mr. Combs should not be released pending this trial. The government's investigation is ongoing. So this is letting us know, hey, we're still investigating, and there may be other co-conspirators' conduct that may be the result of future indictments. There may be additional charges that they may levy against Mr. Combs as a result of what their information may uncover. And we know that at the end of the U.S. Attorney, Mr. Williams' press conference today, he said, if you know any information, if you have any information about any of these events, contact them. And he left some information for a hotline. So individuals can reach out to the government to assist them in their ongoing investigation of Mr. Combs and of these allegations of racketeering and sex crimes. So next we have the argument. So this is their legal basis for requesting that the court deny Mr. Combs bail in this case. So under the Bail Reform Act, 18 U.S.C. 3141, federal courts can determine or order a defendant's detention pending trial upon a determination that the defendant is either a danger to the community or a flight risk. A finding of risk of flight must be supported by a preponderance of the evidence. There are some legal citations. A finding of dangerousness must be supported by clear and convincing evidence. Another grounds for a court to determine that a defendant be ordered detained pending trial is when there is evidence of obstruction of justice. Courts in the Second Circuit have held that pretrial detention for obstruction of justice is appropriate as long as the government can establish by clear and convincing evidence that there exists a serious risk that defendant would threaten injure, or intimidate a prospective witness or juror. There are 4 factors under the law for the court to consider. They are the nature and circumstances of the crimes charged, including whether the person is a violation. Including whether the offense is a violation of Section 1591, the weight of the evidence against the person, the history and the characteristics of the defendant, including the person's character, past conduct, and financial resources, and the nature and seriousness of the danger to any person or the community that would be posed by the person's release. So, the evidence that they use to support, right, the standard is clear and convincing if it's going to be based upon obstruction of justice. The evidentiary rules do not apply, and the government is entitled to present evidence by way of proffer. Okay, so now we're going to move to the discussion. So this is where the government is going to outline, okay, there are 4 factors to consider, and these are how we can prove that we've met that legal burden. So first is dangerousness. So the defendant is charged with serious and violent crimes in the indictment, including physically and sexually abusing women and others for the better part of 2 decades. Okay, so they believe that his detention is warranted in this case because since at least 2008, the defendant has engaged in serious acts of violence, including forcing and coercing women to participate in sexual activity, including acts with commercial workers by using force, financial pressure, emotional abuse, and narcotics. Right, so that's not, okay, second paragraph, that's not all. In addition, the defendant captured significant additional violence, both spontaneous and premeditated. So they're just going to discuss some of the acts of violence that are being alleged against Mr. Combs. And the defendant and other members and associates of his enterprise were capable of premeditated violence, resorting to kidnapping and arson when the defendant's power and control were threatened. Defendant's violence were spontaneous or premeditated and had the effect of exerting his continued control over these individuals. Then they note that they revealed that in searches in March of 2024, there were assault rifles, semi-automatic rifles were uncovered in his homes, which obviously further supports their charge that, there is a pattern of violence and abusive conduct, and he has access to very dangerous weapons and has in the past threatened to use violence to intimidate people to get what he wants. So I think, okay, all of this supports this dangerousness prong. Okay. So here's a summary. In sum, the defendant's long history of violent conduct makes clear that even the most stringent bail conditions will not suffice to ensure the safety of the community. The defendant is a serial abuser who repeatedly assaults and coerces women to achieve his own gratification and uses his vast wealth and position of power in the entertainment industry to conceal his illegal conduct and prevent victims of and witnesses to his abuse from coming forward. They continue, no bail conditions can address the defendant's tendency to become violent when angry or emotional. Anyone in his presence is at risk of abuse and assault. His assaults were serious in nature, resulting in serious injury and requiring medical intervention and long periods of recovery. Therefore, the nature and seriousness of the danger to any person is both real and specific. So this is what the government is saying supports their contention that Mr. Combs is dangerous, and thus they've met this factor when considering whether or not he should be detained during the pendency of a trial. Second prong is obstruction. Defendant engaged in obstruction of justice, including bribery and witness tampering. Kind of gone over that earlier when they contended that, in connection with, okay, wait, let's just read specifically. A civil lawsuit was filed on or about November 16, 2023, alleging years of sexual, emotional, verbal, and physical abuse by the defendant, including allegations describing the March 2016 incident. Following the filing of the lawsuit, the defendant stated in no uncertain terms, "Let me be absolutely clear, I did not do any of the awful things being alleged," and through his counsel, vehemently denied these offensive and outrageous allegations, and saying that the complaint was riddled with baseless and outrageous lies. It was not until the video surveillance footage of the defendant's attack was leaked to the media months later that the defendant was forced to admit that he had, in fact, perpetuated the disgusting attack. Clearly, the defendant is willing to deflect, minimize, and lie to induce others to do so on his behalf to avoid responsibility for his own actions. Now, they're also alleging that he engaged in obstructive conduct after the lawsuit was filed and used intermediaries to talk to potential victims and witnesses to this alleged conduct to attempt to feed the victims and witnesses false narratives about the defendant's conduct. With respect to at least two of these individuals, the defendant's co-conspirators assisted in efforts to protect the defendant. So just 3 days after the filing of Cassie's lawsuit, the defendant made multiple calls to another victim of his abuse and recorded certain of those calls using the cell phone of a co-conspirator. During the call, the defendant repeatedly asked for the victim's support and friendship and attempted to convince the victim that she had willingly engaged in acts constituting sexual abuse. The defendant also assured the victim that if she needed the defendant, she ain't got nothing to worry about. A thinly veiled attempt to coerce the victim to adopt the defendant's false version of events to protect the defendant. Even more concerning, since learning about the criminal investigation, including following the execution of the search warrants at his residences, Combs contacted other witnesses on multiple occasions, including witnesses who had received grand jury subpoenas. So the prosecutors highlight that this conduct, as we just read, is similar to conduct in another case where the district court revoked pretrial release after the defendant in that case engaged in witness tampering. So their discussion of this case is to kind of say, okay, this is what Mr. Combs did. This is what the court found in another case where they said, hey, this person is not eligible to be released into the public. So the conclusion is Mr. Combs engaged in the same kind of conduct, then he also should not be released. Okay. They go on to say that the defendant's conduct go beyond that case where bail was revoked, because even before being charged with the crime, the defendant has taken proactive steps to tamper with potential witnesses' testimony against him. The government is aware through electronic evidence, toll records, conversations with witnesses, and other evidence that the defendant has contacted witnesses, including subpoenaed witnesses, prior to the dates on which the witnesses were required to appear before the grand jury. In addition, the defendant has recorded calls with at least one victim and provided, either directly or through intermediaries, false narratives of the events that transpired so the witnesses would adopt the false testimony. This conduct is even more alarming by the manner in which he carried it out to evade detection, in some instances by having intermediaries make calls on his behalf and recording certain calls on another individual's device. These deliberate actions show that the defendant was aware of what he was doing, was obstructive, and that his aim was to evade detection. Even the most stringent conditions, and that's referring to even if we adopt certain conditions to allow him to be out on bail, including the monitoring of court-authorized electronic devices. That would fail because the defendant would not engage in this kind of obstructive conduct from his home, acting through intermediaries, and using other devices. So right there, the government is trying to preemptively weave in arguments that Mr. Combs and his attorneys might assert in terms of conditions that the court could impose to minimize or prevent any allegation that he attempted to coerce or obstruct witnesses in connection with this lawsuit. And the government is saying, hey, listen, even if you impose these certain conditions on him, it still wouldn't work because at the end of the day, he used other people to help him carry out his plan. So even if the government were to take his devices or restrict his own devices, he would use other people to carry out his plans. And so he simply should not be able to be released on bail during the pendency of a potential trial in this case. Okay, so the risk of flight. So there's a presumption that he's a flight risk. And the crimes that he's charged with include a mandatory minimum sentence of 15 years imprisonment and a statutory maximum sentence of life in prison. The possibility of a substantial sentence is a significant factor in assessing the risk of flight. So now they're just going to go, detail how powerful Mr. Combs is, how many victims he's alleged to have, and what they have, what these witnesses have observed over this time. So, in this case, risk of flight is augmented by the nature of the evidence against the defendant. The evidence against the defendant, which would be made public at trial, includes substantial evidence that is highly sensitive and has the potential to significantly and negatively impact the defendant's reputation. For decades, the defendant has spent significant time and resources ensuring that his criminal conduct avoids public scrutiny. Given the potential penalties here, both incarceration and reputational harm, the defendant has every incentive to flee to avoid prosecution and a public trial. Right? Then they talk about his limitless resources create significant risk of non-appearance, including a net worth that's publicly estimated to be close to $1 billion. The investigation has revealed that he has vast funds and resources, including deep reserves of cash, which would facilitate his evasion of prosecution. At least as of December of 2023, the defendant had access to dozens of bank accounts, some personal and many under corporate entities, which contained millions of dollars. The defendant had over $1 million in personal cash on hand. The defendant has traveled internationally several times per year since at least 2006, and since approximately 2019 has owned a personal plane on which he has traveled internationally. So all this is to support their position that he is a significant flight risk given the reputational harm that a potential public trial will cause to him, and also his significant financial resources, and obviously the amount of time that he's facing if convicted of the charges in the indictment. So the government kind of concludes, given the serious nature of the charges, the strength of the evidence, and the defendant's access to vast amounts of resources, his risk of flight is more pronounced today than it has ever been. And then the final prong is the court should consider the weight of the evidence that is levied against the defendant. And so here we kind of have a little bit of a peek of how much evidence the government has. They write, as to witnesses, to date the government has conducted interviews with over 50 victims and witnesses, many of whom saw or experienced the defendant's abuse. Many of these witnesses corroborate one another, and their accounts are similarly consistent with the other types of evidence discussed below. The government only expects that number to continue to grow, given that the investigation, which is now public, is ongoing. The electronic evidence is similarly vast. The government has sought and obtained numerous search warrants for such evidence, in addition to obtaining evidence voluntarily from some certain victims and witnesses. They have devices in connection with the defendant's arrest. The government has obtained over 90 cell phones, laptops, and cloud storage devices, as well as 30 other electronic and storage devices, such as hard drives, thumb drives, cameras, and surveillance systems. The electronic data comes from the defendant himself, as well as co-conspirators, victims, and witnesses, and chronicles much of defendant's criminal activity as it occurs. There's also physical evidence seized pursuant to search warrants executed at the defendant's residences in Los Angeles and Miami, as well as on his person and the persons of certain co-conspirators. In addition to the firearms and electronics discussed above, the physical evidence also includes other evidence of freak-offs, including 1,000 bottles of baby oil and personal lubricant. The evidence includes records obtained pursuant to over 300 grand jury subpoenas and other voluntary productions. The materials come from over 100 entities and individuals, including communication providers, tech companies, social media companies, banks and other financial institutions, airlines, hotels, car services, and other travel-related companies, escort services, and even the defendant's companies and wealth management firms. Together, this evidence, as well as other evidence gathered, powerfully demonstrates the defendant's guilt and counsels in favor of detention. So, the government's position is when the court considers all of those four factors and the weight of the evidence that they have gathered, it all will lead the court to conclude that they should deny bail and Mr. Combs should be detained during the pendency of a trial. Now, the government says there's no bail package that can assure safety in this case, and in particular, the bail package proposed by the defendant is insufficient because it fails to adequately protect others from the defendant's violence, impose measures to prevent and detect obstruction, or prevent the defendant from accessing his vast resources, including millions of dollars in cash, to evade prosecution, or dissipating those assets to avoid financial penalties for his crimes. So I guess the defense proposal, including certain conditions with electronic monitoring and a $50 million bond secured by the defendant's Miami property. The government says it's insufficient. Given his history of engaging in obstructive conduct and other things that were detailed above. Notably, the defendant's conditions do not include provisions related to his access to electronic devices, which, as outlined above, the defendant uses to engage in obstructive conduct. Nor do the proposed conditions include information related to or restrictions on access to the defendant's vast resources, including his personal bank accounts and the accounts of his businesses and deep cash reserves, which could all assist in his flight. Finally, the proposed conditions do not include conditions that would limit the defendant's potential to engage in violence or abuse, such as drug testing and treatment and surrender of all firearms. So government concludes, based upon all of this, the defendant cannot meet its burden of overcoming the statutory presumption in favor of detention, and there are no conditions of bail that would ensure the appearance and compliance of the defendant or the safety of others. Therefore, his application for bail should be denied. And here, signed by the U.S. attorneys. So, in response to this letter, Mr. Combs, his attorney, has similarly sent a letter to the judge. So here we have it. Mr. Combs' attorney submits this letter to the court for release. So this is his attempt to say that, Mr. Combs is not a flight risk. He is not a danger, and the court should allow him to receive bail. Okay, so I think the beginning kind of outlines statements that his attorney's already made. as a result of Mr. Combs' arrest, that they knew that charges were forthcoming, that Mr. Combs voluntarily came to New York to assist in voluntarily surrendering, and the government arrested him before he had the opportunity to self-surrender. And so this was not the first action Mr. Combs took to show his trustworthiness and lack of flight risk. Indeed, it is part of a pattern ever since March 25th of 2024, after the search of Mr. Combs' residences. He is fully aware that the United States attorneys have been conducting an investigation involving allegations concerning racketeering and sex trafficking, amongst other offenses. Knowing that he would be indicted, Mr. Combs has done everything to work with the prosecutors in ways that are unusual, if not unprecedented. In light of these circumstances, they can rebut the presumption of detention due to his actions during the investigation. And so they want to be released on certain conditions. Now, before we read the proposed conditions that he wants to impose, it is really interesting that they're trying to use his cooperation or alleged cooperation with the government and their investigation as a grounds for why he should be granted bond in this case. And I think what will be more difficult for his attorneys to prove is that his attempts to be cooperative, forward-facing to the government, were not undermined by these allegations by the government that in the background Mr. Combs was attempting to silence witnesses and to prevent people from testifying at trial, trying to alter their recollection of certain events, and trying to bribe them in order to adopt his story of events and not their own recollection. So, I mean, I think that obviously his attorneys have to assert some defense on his behalf, and I think that he will have to address those allegations that have been levied against him if he wants the court to believe that, Mr. Combs's outwardly facing attempts to be cooperative with the government were in fact genuine and were not a means by which to secure a bond if he, like he asserts, knew that there was an indictment forthcoming. Okay, so these are his attorney's proposed package for bail: $50,000 bond, co-signed by his mother, his sister, the mother of his oldest daughter, and his 3 adult sons. The bond being secured by his residence in Miami, Florida, which has an appraised value of $48 million. So the balance of the mortgage has been paid off. Let's see. In anticipation of this bail hearing, on August 20th, 2024, Mr. Combs paid off the mortgage, about $18 million, so that the home could be used to secure a bond and be free of a mortgage. In some ways, this is interesting admission, going back to what the prosecutors argued in terms of his vast resources. His ability to pay $18 million to have a $48 million home unencumbered is just another example of the vast financial means that he has in this case. So he's also securing the equity of his mother's home, and he will agree to restricted travel to the Southern District of Florida and the Southern District of New York to meet with his counsel and attend medical appointments. He will surrender his passport. Oh, so he surrendered his passport, to his counsel on April 1st. His counsel advised the prosecutors of this fact in an email dated the same date. Counsel will provide the passport to pretrial services. The passports of his certain family members were surrendered to counsel after the raids on his home, and it appears to be the names of his children. His mother is Janice, children Chance, Jesse, Delilah, and Love. He's making efforts to sell his airplane, home detention, and all other standard conditions of pretrial supervision. So this is what they're offering. And as the government kind of suggested, there are some gaps in terms of areas where they're concerned, specifically as it relates to his threats of violence and his access to firearms, as well as his use of electronic devices, which the government contends he's used devices to threaten and coerce witnesses in the past, specifically since the filing of the lawsuit by Cassie back in November of 2023. Okay, so essentially, Mr. Combs' attorney is trying to use Mr. Combs' alleged cooperation with the government since he's been under investigation as a bargaining chip to allow for them to for the court's consideration to allow him to receive a bond. Okay, so here we have Mr. Combs' counsel emailed the U.S. attorneys, and he identified himself. So he's saying, hey, I emailed these people, and they did not email me back. On March 25th, 2024, search warrants were executed. He was removed from his airplane and searched. On this date, counsel called the prosecutors and spoke for the first time and indicated that he would accept service of subpoenas for Mr. Combs' businesses. So he took, like he said above, he took possession of Mr. Combs' passport, and he advised the U.S. attorneys that of this fact. He agreed to advise the government of all domestic travel. He's advised the government of his efforts to sell his plane. And he voluntarily relocated himself to New York in advance of his arrest. So this is kind of what he's outlining. Mr. Counsel advised the government that it was in possession of members of Mr. Combs' family members' passports, and he's assisted the government concerning subpoenas. Okay, let's look at that more closely. As stated above, counsel accepted service of 2 subpoenas directed at several of Mr. Combs' businesses in March of 2024. Separate counsel for the entities filed a motion to quash those subpoenas in April of 2024. So a motion to quash is saying, hey, I know you served these subpoenas, but actually we're not going to produce documents, and we believe legally that we don't have to produce documents for these exact reasons. So in May 2024, upon becoming sole counsel in connection with the criminal investigation, he advised that he would withdraw the motions to quash, and instead they would meet and confer with the government to minimize the number of requests on which the parties disagreed, and he began to gather documents responsive to the subpoena. So, I mean, that's an interesting fact. I would be curious to know the specifics of the meet and confer efforts. So, just like a little bit of background. Like I said before, a motion to quash is when someone says, hey, legally I'm not required to produce these documents that you're requesting in the subpoena, and here are the legal reasons why. So the motion is asking the court to make a determination about if the party seeking to squash the subpoena has the legal right to not produce any documents. So what they're saying is, once this attorney became Mr. Combs' sole counsel, he intended to work with the government to come to an agreement regarding what documents these business entities would in fact produce. Now, what is more curious is what kinds of documents they did in fact produce, and if there were still further items in which the government wanted documents, but they weren't able to come to some agreement. Now, it's pretty customary for attorneys to have to meet and confer regarding requests for documents